Thank you very much for your kind introduction, Professor Kamina Gunaratne, Chairperson of the Plenary Sessions, distinguished members of the head table, and distinguished guests, dear students, ladies and gentlemen. I am very much privileged and I am thankful for being invited to deliver a speech at this important event. I have chosen the topic Administration of Justice with special reference to human rights protection, challenges and prospects. In fact, I am very thankful to Honorable former Attorney General Mr. Paritha Fernando for paving way very much with having references to incorporation of international law and the emerging trends with regard to creeping towards monism, which would be the crux of my presentation as well, with some highlights on judicial activism and some selected jurisdictions. Perhaps I might skip a few of slides considering the time constraints as well. So we find international law is very important and include basically treaty law and customary international law as predominant sources of international law. But at the same time, international law does not direct towards the obligatory states as to which way should be used in incorporating international law into their domestic spheres. As a result, we find number of diverse practices as well as patterns emerge in different jurisdictions. Perhaps some countries may prefer monist tradition of international law receptions, and in certain cases that could be the dualistic tradition of international law incorporation. I think for this learned audience, I do not want to go much into detail the differences between monist school of law and the dualist school of law. But I want to say that basically through either monism or dualism, the last ambit is to see the flourishing trends at the global level to be transformed to the domestic level, and finally the benefit to be given to the people at grassroots level. But unfortunately, we find the reality in the ground level sometimes, especially with regard to the cases where the victims of human rights violations are not benefited most of these emerging trends at the global level due to many reasons, but perhaps could be due to the lethargy of either the executive branch or the legislative branch of the state organs. Therefore, I thought that I should specifically focus on to discuss whether the judiciary can alleviate this lethargy of those two branches, namely the executive and the legislative branches, through the judicial activism, and whether it could be sort of a way of achieving justice to the people in the countries from maybe the status apparatus which might lead to the violation of their very human rights. When we look at the monist school of law and the dualistic school of law, we find in monist countries mostly that we find, even without the need of an enabling legislation, treaty that are ratified or acceded by the states can be incorporated into the domestic laws, and these treaties could be called as self-executing treaties. But in the world that we find that rather most countries are being designated as dualistic countries, they require sort of an expressive act by the legislature in the name of enabling legislation, and without which in most of those countries judiciary are reluctant to incorporate those international standards to which the domestic states become a party, and highlighting the need of having an enabling legislation. So with these new trends that I want to discuss with you all today, whether Sri Lanka's judiciary is free to interpret Sri Lanka's obligation under international law in this backdrop into our municipal law of the country in pronouncing its decision in a case concerning issues of international law without an enabling statute. In certain human rights cases, in fact, some of the judges, including Australian number of judges, have felt that they should administer justice through judicial activism, although they have not meant to depart from the traditional dualistic tradition. However, they have administered justice to victims of human rights violations through different judicial interpretations and also by way of creeping through monism. So I think therefore I should spend a few minutes to explain the creeping towards monism tradition in the world and how that we can move away from the positivistic school of thoughts and from the dualism and how this has been achieved in some of the selected jurisdictions. I will first take example from United Kingdom with regard to the incorporation of treaty law and customary international law by citing some of the known cases by most of you, that is the Trent Trading Corporation versus the Central Bank of Nigeria. In this case, Lord Denning said, I quote, seeing that the rules of international law have changed and do change, and that the courts have given effect to the changes without an act of parliament, it follows to my mind inevitably that the rules of international law, as existing from time to time, do form part of our English law. And he continued to say, we should give effect to those changes and not be bound by an idea of stare decisis in the international law. In this case, actually, the Lord Denning's very word shows us that the domestic courts have responded to important changes within international law by moving away from dualism to monism, so as to accommodate these changes. Nevertheless, it was not uniform. However, while treaties required to be transformed into law by legislation, a customary principle is incorporated automatically into English. I think this is one of the very important areas that we should try to pick up by our own judges. Maybe that you are not able to bring the principles coming out from the stipulated treaties as in a treaty provision, because we could be held up due to the dualistic tradition. But if we can pick up the embedded customary international law principle within the treaty law, sometimes the judges can go away or move away from the dualistic tradition and they can incorporate those customary international law principles that is to be found in the treaty law, which has not been yet to be transformed to the domestic law through any enabling legislation. So, if I talk a little bit about the treaties containing customary international law, we find principles in multilateral treaties and civil instruments came to be considered as containing customary international law, and by this way, many judges have already attempted to incorporate such treaty principles through a monist approach. So, if we take one of the very important human rights conventions, you all aware, ICCPR and ICSCR, the twin human rights conventions of 1966 now are considered to be formed customary international law. As a result, many of the later human rights conventions largely spell out the same principles then that are also to be found in these two foundational documents on human rights are also reflecting customary human rights law principles. Many treaty law principles stipulated in human rights conventions has now as a result become part of customary international law, and this would be the case even in international humanitarian law, which are also to be found in the Geneva Conventions, protocols as well as Hague Conventions and regulations. Now, if we look at the proposed change that the judges may use to creep towards monism, going away from dualism, there could be some possible objections. One may argue that this is an undemocratic lawmaking by the courts. Counter arguments could be the states through their own practices and with opinio juris undertake such customary international law. Again, that you all understand the fact, unlike the treaties, that for customary international law principles that you do not need to sign or ratify, but through the state practice, and as well as the opinion jurists that the states, if they are willing to accept them as law, as evidence of law, so then that will become obligatory on them. Therefore, that those customary international law principles would be binding on them, and this is nothing against sovereignty of states. Also, if the executive wants to object to this kind of judicial activism, it can undo a judgment if the judges have already used their judicial activism and try to incorporate customary international law principle into their domestic law, bypassing the legislature, so that can be undone by the legislature by a future legislation. I will bring an example to that effect from Australia, citing Teo versus Minister for Immigration of 1995. In this case, the Australian High Court used the Convention on the Rights of Children to invalidate the deportation order against Teo made by the minister on the basis of Teo's convictions. So here what the courts tried to invoke has been the best interest of child. That is one of the fundamental principles of Child Rights Convention, because 7 children under the parenthood of Teo has been affected if he is to be sent back to Malaysia, where he was his original inhabitants. However, now we can see the decision of this Australian High Court has been subject to much criticism, and as a result, the decision of High Court was overturned by legislation, making the exercise of the discretion by the minister have priority over other considerations. So I will bring one example from judicial activism in India, taking the time considerations also into account. The Indian courts have taken the view that it is the executive which agreed to the treaty. The executive should ensure that the treaty becomes law in the state. Where there is undue delay by the executive and legislative branches in passing the legislation transforming the treaty into domestic law, judiciary can take the lead in order to protect the rights of people. I think you might be very familiar with the case of Wasantha versus State of Rajasthan of 1997. This judgment was unprecedented for several reasons. The Supreme Court acknowledged and relied to a great extent on international treaties that had not been transformed into municipal law. The Supreme Court provided the first authoritative decision of sexual harassment in India and confronted with a statutory vacuum it when creative and proposed the route of judicial legislation. So I think there could be some brighter future that we can forecast even from the Sri Lankan cases. Therefore, I thought that I should discuss or present to you one of the recent judgments from Sri Lankan Supreme Court, that is Manohari versus Secretary of Ministry of Education in Sri Lanka of 2016. In relation to fundamental rights, sexual harassment experienced by a woman teacher was determined as a violation of the right to equality and non-discrimination for the first time in 2016 in a judgment that also involved the Convention on the Elimination of all forms of discrimination against women for the first time without having seen the act passed in Sri Lanka. So actually I am not going to discuss about why that the human rights principle should be incorporated to any country's domestic law, but maybe that I can later I can share my slides with you all for the students especially. But I want to just highlight about the declaration containing the Bangalore Principles on the Domestic Application of Human Rights Norms of 1988. These principles were the outcome of a meeting of leading lawyers of the common law world, and this declaration says it is within the proper nature of the judicial process and well-established judicial functions for national courts to have regard to international obligations which a country undertakes, whether or not they have been incorporated into domestic law. That is very important. For the purpose of removing ambiguity or uncertainty from national constitution, legislation, or common law. However, the Bangalore Principles have helped many judges of dualistic countries, that is very important, to be free from the rigid dualism developed by the English common law. The crucial idea of Bangalore Principles was that international human rights law might sometimes provide guidance to judges in cases concerning human rights and fundamental rights where their domestic law is silent. I quote from Justice Michael Kirby, Australia, that he says after having attended Bangalore meeting, he has found some cases came before him in his courts, and he began to see the way in which a reference to international law can be done when the domestic law seems to be cited. So one of the occasions could be that he firstly used this creeping towards monism, using the Bangalore principles, that was Plattridge versus Grace Brothers Private Limited. I am not going to read out the facts of the case. So I will now try to come to Sri Lanka actually, having some explanation based on the role of dualism, which has been diminished in modern world much more time. But in Sri Lanka, Sri Lanka's judicial activism in terms of international law incorporation shows diverse trends. We are not very uniform. With regard to treaty law incorporation, Sri Lanka follows dualistic school of law as similar to many of other Commonwealth countries. But we find, as you see in this slide, in certain cases we were very much pro-dualistic, and very rarely we have become pro-monistic. Cases like Intigri Bandara Colombo versus the Minister for the Industry. So, which is known as a power judgment. You all aware, as Mr. Partha Fernando also highlighted, the judgment used a concept which is only to be found in international environmental law, that is a customary international environmental law principle, that is the notion of intergenerational equity. Actually, this principle has been highlighted by Justice Veeramantra in the case concerning Hungary versus Slovakia, having made some special references to the context of Sri Lankan philosophy and our legacy. So in this judgment, Justice Amar Singh stated that I am not going to read out the entire quotation, but he says, either expressly enacted law become a part of the domestic law by adoption of the Superior Court of Record and by the Supreme Court in particular in their decisions. I mean that sometimes maybe the Sri Lankan judges can use international law developments in the absence of even an native legislation. That means we have been creeping towards monism in this particular judgment. However, that is not the case in Sri Lanka. We find sometimes the trend has been in reverse. Although the Bulankulama case was a triumph for monism. We find in the controversial case decided by the Supreme Court of Sri Lanka, that is the Nalaratnam Singrasa versus Attorney General case, that it was not the same positive thought for the judicial activism has been proved by the Sri Lankan judiciaries. In this case, in fact, that we wanted to see International Covenant on Civil and Political Rights has been transformed to our country by way of having an enabling legislation. So with that, now my final slide that you will see which way forward. Whereas that we see some cases in Sri Lanka that judges have become very positive and they have used judicial activism, and some attempts to creep towards monism, and some cases has been in reverse, and we were again going back to the very rigid dualistic system. So however, what I should say is that finally who should be benefited? The benefit should go to the victims of those rights violation cases. Because final analysis, what we should do is, human rights law has been tailor-made to protect not the state but to the people, and their rights are most paramount. Thank you very much.